This is Bloomberg Law with June Grasso from Bloomberg Radio.
Can't stop.
Won't stop.
Can't stop.
Won't stop.
Can't stop.
Won't stop.
Hundreds of protesters were outside the Supreme Court today to support a 30-year-old federal ban on guns for domestic abusers. Inside, the justices suggested during oral arguments that they would not strike down that ban that's been used to block more than 77,000 gun sales in the past 25 years. And it didn't even seem like it was a hard issue for the justices. Both liberals and conservatives sounded persuaded by arguments from the Solicitor General that the prohibition is in line with the long-standing practice of disarming dangerous people. My guest is Second Amendment expert Adam Winkler, a professor at UCLA Law School. Let's start with the big question. Did it seem like justices across the board were inclined to uphold this federal gun ban for people subject to domestic violence restraining orders?
It did. It felt very one-sided in the Supreme Court today, and it felt like that almost all the justices, if not all the justices, were inclined to uphold the federal ban in this case.
This is the first test of last year's ruling that strengthened Second Amendment protections and established a constitutional right to carry a handgun in public. So in order to understand this, I think we have to, explain how the historical analysis approach has caused confusion in lower courts and led to striking down gun control laws. So maybe you could just give us a briefing on the historical analysis.
In the Bruin case, Justice Thomas's majority opinion said that for gun laws to be constitutionally permissible today, they must have historical analogs in the 17 and 1800s when the Second Amendment was adopted and the 14th Amendment was adopted, incorporating the Second Amendment to apply to the states. As a result, courts have really struggled over the last year or so trying to find gun laws back in those days that are sufficiently analogous to many common sense mainstream gun laws that we have today. Truth be told, many of our gun laws are kind of 20th century inventions, bans on felons possessing firearms, bans on the mentally ill possessing firearms, and the issue in today's case, ban on domestic abusers possessing firearms. These are laws that don't have any obvious analog in the 17 and 1800s, and so this law was struck down by the Fifth Circuit, just like courts around the country have been striking down gun laws for lack of a clear historical precedent.
So then how did the justices get around that lack of a clear historical precedent and all end up seemingly in favor of this ban?
Well, first of all, I think it's important to note what Elizabeth Proligar, the Solicitor General, began her oral argument with by noting the statistics that show that domestic abusers with firearms are an incredibly deadly mix, and that every state in the union, well, not every state, I think it's 48 states and the federal government, have prohibited domestic abusers from possessing firearms, showing that what she intended to do was not just rely on the history and tradition, but on the common sense idea that some people are too dangerous to have firearms. What the court seemed to be inclined to do is allow the government to frame their gun laws at a higher level of generality. You don't have to show that there's a history and tradition of domestic abusers being prohibited from possessing firearms, and of course there isn't a long history and tradition of that, but maybe you could show that there's a history and tradition of prohibiting dangerous people from possessing firearms, and domestic abusers are just a modern-day understanding of people who are just too dangerous to have guns.
So Justice Thomas wrote the Bruin decision. Was he in line with what you just said?
It seemed Justice Thomas did ask several questions from the bench. It's kind of surprising to go to the Supreme Court now and to see how active Justice Thomas is as a questioner. Before COVID, he didn't seem to ask many questions, but it really has changed. He was an active questioner, and he didn't really show his cards very much. He did press the Solicitor General to defend the standard that they were offering, but by and large, it was hard to get a read on exactly Justice Thomas's views. But the views of most of the other justices came through pretty loud and clear.
And tell us a little bit more about their views.
Well, the Chief Justice kept asking, isn't it obvious that this is a very dangerous person, this Rahimi? He's had several incidents where he's fired firearms and been irresponsible with them. Obviously, Justices Sotomayor and Kagan and Jackson seemed more on the side of the Solicitor General in the United States, although I will note that Ketanji Brown Jackson did ask some very, very difficult questions of the Solicitor General today and pushed her to really define the boundaries of the argument that she was making. One could interpret that as skepticism, or more likely, she wanted the Solicitor General to give her the really good arguments that she could use, Justice Jackson could use, when she goes into conference with the other justices in the next couple of days.
Yeah, so Justice Jackson said, what's the point of going to the founding era? Did she and the other liberal justices seem like they wanted to use the case to revisit that history-based test?
It did appear so, although maybe she's not that optimistic that she could do it. But it did seem like she was pressing that it's very hard to defend this domestic violence abuser ban when people are subject to a restraining order in light of the history and tradition approach that the Bruin court offered. Although Bruin said that you should look for analogous laws, I think that at the end of the day, the government is hard-pressed to draw a very close analogy. Instead, the analogies were very general and didn't exactly apply on point.
Did a majority of the conservative justices seem to want to limit any decision to the facts here? Justice Neil Gorsuch said at one point, do we need to get into any of that?
It did seem like several of the justices, including Justices Gorsuch, Thomas, and Alito, were looking for ways to narrow the consequence of ruling against Rahimi in this case and in favor of upholding the law, talking about whether there might be different as-applied challenges that someone could bring, or whether there might be some common law defenses that one could bring to a charge that one was possessing a firearms illegally in violation of a domestic violence restraining order. And several of the justices, at least Justice Alito, expressed some discomfort with the idea that these domestic violence restraining orders could be very long-lasting and yet don't have very serious procedural requirements that correspond with broad notions of due process, perhaps.
The Solicitor General said the court should use the case, the present case, to give more guidance to the lower courts and to correct lower courts', quote, profound misreading of the Bruin decision. Do you think we'll get any major statements out of this ruling?
I think that's going to be one of the big questions. Is this a really narrow ruling that just cobbles together a majority, or is it an opinion that will provide more guidance to the lower courts? Justice Kagan specifically asked about that and about the necessity, and the Solicitor General had a very clear and precise answer that there were 3 errors being committed by the lower courts. They were only looking to regulation and not looking to other historical sources. They were looking at regulation, but were really looking for twins rather than for historical analogs, and also that the absence of regulation should not always be read against the government, especially when a problem like domestic violence was not really thought of as a problem back then.
So I admit that I find this historical analysis test with Second Amendment cases just bordering on ridiculous. Were there any clues as to whether the conservatives remain behind the historical analysis that Thomas put in place?
Well, I think that the Solicitor General made a very strategic choice not to challenge the history and tradition test of Bruin, but instead seek to, if anything, recapture its fluidity, its ability to be useful to uphold laws, not just to strike down laws. And so she was not asking the court to abandon the history and tradition test. Rather, she was saying that the lower courts have been misapplying that test, and that to capture the true essence of that test means that you should approach the issue the way she did, at a slightly higher level of generality, focusing on dangerousness, rather than looking for historical precedents of domestic abusers being prohibited access to firearms.
Do you think then that this reasoning would apply to gun control measures that deny firearms to other potentially dangerous people, for example, drug addicts or felons?
Well, those questions, of course, will have to be answered by the court in the coming years, but it certainly was on top of mind for some of the justices. Justice Kagan asked specifically of the public defender who was challenging the law, well, you say that bans are not constitutionally permissible of the sort, but what about mentally ill people who have been prohibited? Is that okay? And the attorney kind of hedged, prompting Justice Kagan to say that you're running away from your own argument because of its untenable consequences. And indeed, I think it was very much on top of mind for the justices that if they struck down this law, it would be hard to figure out how they would uphold bans on felons possessing firearms or bans on drug abusers possessing firearms, and even something like background checks. Because, again, we didn't have such laws or really anything like them in the 17 and 1800s.
Yeah, Justice Kavanaugh expressed concerns about that. Did any of the other justices talk about background checks?
No, that was only, if I recall correctly, Justice Kavanaugh, who asked about historical ban on sale, and the attorney challenging the domestic violence restraining order ban in this case said, well, there is a stronger historical tradition to regulate commercial sales. But at the same time, he said, well, we're dealing with a ban on possession of firearms in the home. And he said there really isn't any history and tradition of bans on people having firearms in their own home.
So if you had to guess, would you guess that it's going to be a limited opinion or a broader opinion?
If I were to guess, I would say this is likely to be a 9-0, maybe 8-1 or 7-2 opinion. And I think because of that, the larger the majority, the less likely it is to be very far-reaching. That it may be one of these cases that gets assigned to Justice Gorsuch to just do as little damage as possible to the Bruin test. But I do think that this case was, no matter how big the majority is to uphold the federal law here, if indeed the court does uphold the federal law here, it will be very good news for gun safety reform advocates. They've been struggling to defend gun laws in courts, bans on guns without serial numbers, bans on assault weapons. Even last week, a court struck down the restriction on felons possessing firearms. So if the court does move to this higher level of generality and says that government can prohibit people who are dangerous from having firearms, it would provide a basis for defending a lot of our core gun laws that we really rely on in modern 21st century America.
And Adam, last week the Supreme Court agreed to decide the fate of the federal criminal ban on bump stocks, the attachments that let a semi-automatic rifle fire much like a machine gun. What do you make of that? Do you make anything of it?
No, I don't make much of it. I think that is really an administrative law case, and it's about whether the administrative agency went too far in interpreting its powers under the Gun Control Act and other federal statutes that regulate firearms. And so I think that although they both deal with firearms regulation, both these cases, they're very different. One's a Second Amendment case that's going to be decided on Second Amendment grounds and have huge impact on how other Second Amendment cases are handled. Whatever the court does on the bump stocks will be much more important for administrative law and the scope of administrative agency authority under the Constitution, and thus will have a much bigger impact well beyond guns to all sorts of regulatory areas where administrative agencies weigh in.
There are certainly a lot of administrative law cases this term. Thanks so much, Adam. I always appreciate your insights. That's UCLA law professor Adam Winkler. California has been a leader in legislation benefiting undocumented residents, such as allowing them to get driver's licenses. Now the state's higher education system is looking to be their largest employer by relying on an untested legal theory. University of California regents are fast approaching a self-imposed deadline of November 30th to issue a plan that makes the school system the first public institution to hire students and staff regardless of their legal immigration status. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, explain this plan, or this plan that's forming.
Well, here's what's happening. The government of the state of California is trying to take an interesting legal argument in order to be able to have their state institutions, such as their state universities, be able to employ undocumented individuals within their universities. And they're trying to do that on the basis of a novel legal argument that the federal immigration law doesn't apply to them.
There's a federal law that makes it illegal for employers to knowingly recruit or hire undocumented workers.
So basically, here's what happens. So 8 U.S.C. Section 1324A is the title of the immigration code, where they say that no employer can hire for wages for actual labor foreign nationals unless they actually have been given authorization to work in the United States. So either they have to be a citizen, a lawful permanent resident, or they have to possess a document from the federal government that permits them to lawfully work in the United States. And if not, the employer can be subject to a host of fines and potentially prison time. But what the state of California is saying for its universities and its other state institutions, potentially what they're saying is that they are not subject to that law because there are a number of Supreme Court cases in other contexts that talk about when the federal government wants to subject state governments to various policies and employment laws and other things, that they actually have to say that. And so the fact that the federal government didn't say that specifically here, that state governments and local governments are considered employers, the idea would be that perhaps these state governments and local governments don't then have the duty to verify the employment authorization status of employees in order to hire them as legal workers in those institutions.
Where would the federal government mention the states explicitly?
Well, they would have to say it in the statute. So the statute just says any employer. And so the question is, does any employer specifically include the state, or does it not? Because there is the argument that, and this would have to be for the courts to decide, that in addition to saying any employer, the statute would also actually specifically have to say any employer includes state and local public entities.
Do you think that that's a very broad reading?
Here's the issue. There are so many cases on the flip side of the issue of what state governments are permitted to do vis-a-vis immigration law. The main one being Arizona versus the United States, which says states can't take matters into their own hands to enforce immigration law. And then you have the Fifth Circuit case where Texas had sued the Obama administration about not having sufficient border funding. And there have been a number of cases about states having standing, et cetera, where the courts have not been amenable to these issues of states taking matters into their own hands vis-a-vis immigration law and saying that laws either apply or don't apply to them. Basically, the federal government has been given by the courts this large authority to say, here's what the immigration law is, here's who it applies to, here's who it doesn't apply to. And so it will be interesting to see if California does this. Could it survive a court challenge? But an actual other interesting question is, would the Biden administration actually engage in a court challenge against the state of California, or would it just simply let sleeping dogs lie and not do anything and wait for some subsequent administration to do it? So there's a lot to be considered here, because it's not necessarily intuitive that the Biden administration would sanction California for doing this. So both things would have to be seen. A, would California do this? B, would the Biden administration either engage in employment sanctions or engage in some other declaratory or injunctive relief court case to try to get this practice to end? And then see who would prevail if those two things actually end up happening.
In an election year, it seems unlikely that the Biden administration would go after California, do you think?
I mean, it seems very difficult to think that it would happen immediately. I think it's the kind of thing where they would say, look, we're taking it under advisement, we're investigating the claim, et cetera. And then the issue is, would there be sufficient political pressure for them to actually go in and sue the state of California? Because there's two ways to initiate this. You can either sue the state of California for declaratory/injunctive relief on their just general program that permits this, or you could actually go to the employers the way ICE does when any employer is hiring undocumented people, and just actually do an enforcement action and say, hey, stop employing these people. And then, the state can do the litigation. So either way, both of those are options, and it would be very interesting to see how the Biden administration would respond to this. Or maybe they would do nothing. And I don't have an immediate inclination like I usually do on what would happen, because I think it's just such a new possibility that I don't think the Biden administration is prepared for or ready to consider this yet.
Could California taxpayers sue? I'm looking for a group that would have standing to sue.
Well, here's the problem. I don't know that California taxpayers would have standing to sue under this same now Biden versus Texas decision that dealt with generally this issue of prosecutorial discretion, and that being the federal government's role. If you recall earlier this year, the Supreme Court said that the states can't get involved in forcing the federal government to enforce immigration law when they believe that the federal government is not sufficiently enforcing immigration law. And so I don't know if taxpayers can do it. Here's an interesting group that might be able to do it, is if there was some sort of labor union that would be formed that would say, we're having to compete against these undocumented workers for jobs. Perhaps they can do it, because there have been labor unions that have sued under similar theories, and they've been allowed to have standing in the courts to do that. So I do think perhaps if anti-immigrant folks can form some sort of labor union or consortium of workers, or can convince one of the labor unions to sue, it's possible that that group would have standing in order to do this.
This is a very elemental question, but they'll be getting taxes taken out. Do undocumented people file taxes?
Well, this is always one of the fascinating parts of undocumented migration, is that to the extent that income gets withheld from undocumented immigrants, which actually happens all the time because it happens under two different regimes. One would be that the undocumented immigrant gets this thing called a TIN, a taxpayer identification number, which is basically out in the open. Everybody's admitting that there's money coming in to the undocumented immigrants, and it's going under this taxpayer identification number, and it's basically the employer and the employee saying, look, we may have many other legal problems, but we don't have a tax problem. We're doing everything right tax-wise. That's one potential option. The other option that happens already is many times undocumented people will actually take somebody's Social Security number and just use it, and so money's being paid on that number, but it's not that person who's working. And so what I'm saying is the federal government is making money off of that work and is not actually paying any benefits. So what actually ends up becoming very interesting is when the Congress proposes these bills to legalize undocumented people, for some period of time, this actually becomes a huge revenue raiser. There's all this money being paid in payroll taxes, and there's no money being paid out. But eventually, once people get citizenship, then they end up being able to accrue that money back. But if they don't end up ever becoming citizens, if these people end up becoming unlawful for their whole lives and just working at California state institutions, this actually becomes a huge revenue raiser for the federal government, oddly enough.
Coming up, I'll continue this conversation with Leon Fresco. What might a budget compromise on immigration look like? I'm June Grasso, and you're listening to Bloomberg. I've been talking to Leon Fresco of Holland Knight about California's higher education system, looking at a plan that would make the school system the first public institution to hire students and staff regardless of their legal immigration status. It would rely on an untested legal theory. Leon, I have another very basic question.
No problem.
So I was reading about all these undocumented students. They're in graduate programs. You know, some states are paying their tuition. Is there any danger ever? I mean, do they live in fear of ICE knocking at their door, or is that not a thing anymore?
Well, I would say here there's three components of this. One, there's a number of these young people who are protected under DACA. So those people have zero fear at the moment, other than that DACA could end up finally being stricken by the Supreme Court when it gets there. That's working its way up the courts, and there are court rulings saying that DACA is illegal, but that are stayed pending Supreme Court review. So there's that, but I mean, there's not an immediate fear, but there's a sort of longer-term fear. Then there's the group of people who say, well, at least it's the Biden administration, and the Biden administration has this sensitive locations policy where they say they won't go into places like schools or courts or churches to deport people. So at least while those individuals are in school, they have some sense of security that they feel that ICE won't actually engage them in these locations to try to deport them. And then there's the third situation, which is, okay, well, what would happen if either these folks are detained not in their university, or perhaps the Trump administration comes in and changes all these rules? Well, then that's a whole third bucket. But for the moment, people are in usually these first two buckets because they're either protected by the fact that they're on the school campus, or even further protected by the fact that they currently have DACA.
And California has been a leader in legislation benefiting undocumented residents?
Yes, and they have these two main laws that they're known for. One is this thing called the Trust Act, which is this huge sanctuary state enforcement regime, which basically says that unless the person is a very, very violent criminal, no state or local authorities of any kind are permitted to interact with ICE or assist ICE in any way, shape, or form with regard to ICE's ability to detain or remove foreign nationals who shouldn't be in the United States. So that's one main thing that they do. And then the second main thing that they do has to be on the benefit side. They provide undocumented people with health care under the California Emergency Medicaid program, and they also are very generous with regard to their policies in terms of not allowing private detention facility companies to get licenses to operate in California, and in terms of giving people scholarships and things of this nature. So there's all kinds of ways that they impede immigration enforcement, but also encourage people to live in California even if they do not have lawful immigration status.
So what's happening at the border? Because there are so many other crises going on. There hasn't been as much focus on it. But is immigration up?
Well, yes, the numbers are very high on the border at the moment. And so what's happening is we're going to have a very interesting confluence for November 15th, which is when the government funding is supposed to run out, which is that the current new Speaker of the House, Johnson, is saying that there has to be something on the border done in order for funding to continue for the federal government. And the Biden administration and appropriators, who I've actually personally spoken to on the Democratic side, realize that probably something is going to have to give here. And the kinds of things they're talking about deal with this process of this initial screening of people. Instead of just saying that if you articulate any kind of claim, you get to stay in the country, raising the stakes on how detailed and how meritorious the claim has to be in order to initially be able to stay in the United States. There's a lot of conversation about this. And there's also a lot of conversation about this theme we've been talking about in the past, about keeping people in ICE detention if they have no place to go, if they don't have a sponsor who's going to agree to house them. And so I think both of those areas are areas that are actually legitimately being talked about by Democrats and Republicans. I don't know if there will end up being an agreement, but I think there is some understanding now for the first time that there's going to need to be some movement there in order to stem the tide of what's happening on the border.
Because we've discussed this before, and there was a New York Times article about how some of the migrants are coming with addresses that they've been given from other migrants so that they could show them and say, oh, I have a place to go. And it's not actually true. It's just an address.
Correct. The idea is that you will actually need a U.S. citizen or lawful permanent resident to come forward and say, here's my income, here's my residence, here's an affidavit or my license or whatever that shows I'm me and that I'm willing to actually sponsor this human being in my house. So this is the kind of thing that's being contemplated right now. Those discussions are happening, but we'll have to see if they end up happening, because there's a lot of pressure also on the left flank of the Democratic Party not to do this without some sweetener in exchange. And the kinds of sweeteners they're talking about are DACA, which the Republicans will never do. And so there's other sweeteners that are less, in terms of at least giving people who can make it through a higher threshold at the beginning. Well, if they can make it through, then allow them to work on day one so that there isn't this idle period where they're not working. That's very interesting stuff, and so that's potentially a compromise, but we'll have to see what happens.
So today, the Ninth Circuit is going to hear arguments challenging the Biden administration's asylum ban.
Yep.
Tell us a little bit about this and where you think this is going.
Well, the Biden administration has tried to have sort of a carrots and sticks approach where they tell people, move to the ports of entry to ask for asylum so that you don't have to actually sneak across the border to do it, because we don't want you doing that. And if you do that, we won't let you actually apply for asylum. And so there's a ban on that. And the Trump administration had tried this. There was some preliminary discussion during the Trump administration and an initial Ninth Circuit decision saying that it was illegal to have this kind of asylum ban because the statute says anybody can apply for asylum even if you've crossed illegally, and so that you can't make crossing the border illegally one of the discretionary factors later that you can use to deny asylum, which is what the Biden administration has tried to do and has what the Trump administration tried to do previously. And so this is now going for renewed consideration in the Ninth Circuit to try to see if this is true, and it'll eventually make its way to the Supreme Court because the Biden administration definitely wants to be able to have this asylum ban in place. Now, what's interesting is this asylum ban doesn't actually end up banning anybody. It just says you can't get asylum. You can get something else called withholding of removal that allows you to stay. It just doesn't give you a path to a green card or citizenship or being able to petition for your relatives, but at least you are able to stay. And so I don't know how much of a deterrent this ends up being, and at least numerically we've seen it hasn't been much of a deterrent, because at the end, it's not that really people are coming here for quote-unquote asylum. They're coming here to quote-unquote stay. And so that ability to stay isn't hampered by this asylum ban. It's only the ability to get a green card or citizenship or be able to apply for your relatives that's hampered by this asylum ban.
I haven't come up with an immigration question yet that you haven't been able to answer, Leon, but I'll keep striving toward that. Thanks so much. That's Leon Fresco, a partner at Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.